Ever wonder how sexual crimes were handled centuries ago? Did victims get justice in medieval times? Number 10. Consent was often about property rights. In medieval legal systems, rape wasn't primarily viewed as a violation of a person's bodily autonomy as we understand it today. Instead, it was frequently framed as a property crime against a woman's father or husband. This perspective stemmed from the deeply entrenched patriarchal structure of medieval society, where women were considered under the protection and authority of male relatives. The Anglo-Saxon laws were particularly clear about this property aspect. When a woman was sexually assaulted, compensation often went directly to her male guardian rather than to her. This compensation system, known as weregild in some regions, effectively put a price on the violation, but that price was considered payment for damaging someone else's property or honor, rather than for the trauma experienced by the victim. In many medieval European legal codes, the punishment for raping a virgin was more severe than for raping a married woman or widow. This wasn't because virgins were considered more deserving of protection as individuals, but because their virginity was viewed as a valuable asset that affected their marriage prospects. A nobleman's virgin daughter represented a valuable alliance opportunity through marriage, and sexual assault damaged that value. This property-based understanding of sexual crimes had profound implications for how medieval society approached justice in these cases. Records from medieval courts across Europe show that cases were often settled with financial agreements between the perpetrator and the woman's male relatives. Justice was less about addressing the woman's trauma and more about restoring balance to disrupted social and economic relationships between men. The exception to this property-focused approach sometimes appeared in ecclesiastical church courts, which occasionally showed more concern for the moral and spiritual dimensions of sexual violations. However, even church authorities often framed sexual assault as a sin against chastity or marriage, rather than as a crime against the victim's personhood or autonomy. Number 9. Marriage could erase the crime. One of the most troubling aspects of medieval rape law was that in many jurisdictions a rapist could escape punishment by marrying his victim. This practice persisted across various European legal systems for centuries. The reasoning behind this bizarre solution reveals much about how medieval society conceptualized rape. In places like medieval Spain, France, and parts of Italy, if a rapist proposed marriage to his victim, and she, or often her family, accepted, all criminal charges would be dropped. Court records from 13th century Valencia show multiple cases where men accused of rape offered marriage as a legal resolution, and such offers were frequently accepted as satisfactory remedies by local authorities. This practice wasn't considered problematic under the prevailing social logic. If marriage was the socially approved context for sexual activity, then retroactively placing the assault within marriage seemed to solve the problem. This practice had devastating consequences for victims. Women who had been sexually assaulted were effectively forced to spend their lives with their attackers. The emotional trauma this caused wasn't considered relevant to the legal process. Instead, the focus remained on restoring social order and preserving family honor. The Catholic Church's position on this practice was complex. While some church authorities criticized forced marriages following rape, others viewed marriage as an acceptable solution that prevented the sin of non-marital sexual activity from continuing. Pope Alexander III's decretals in the 12th century tried to forbid forced marriages, but the practice continued in many regions despite these pronouncements. This marriage solution also created perverse incentives. Historical records from places like medieval England and France contain cases where men admitted to raping women, specifically to force marriage, particularly when the victim came from a wealthier family or higher social status than the perpetrator. It became, in some instances, a strategy for social advancement rather than a crime to be punished. Number 8. Social status determined legal outcomes. In medieval justice systems, the social standing of both victim and perpetrator often mattered more than the details of the crime itself. This was particularly true in sexual assault cases, where the hierarchy of feudal society directly shaped legal outcomes in ways that modern people would find shocking. Court records from medieval England, France, and the Germanic regions show a clear pattern. When the accused rapist held higher social status than his victim, convictions were rare. A nobleman accused of raping a peasant woman faced significantly fewer legal consequences than a peasant man accused of the same crime against a noble. The 13th century English legal scholar Henry de Bracton explicitly noted that punishment should vary based on whether the victim was a noblewoman, a burgher's wife, a peasant woman, or a nun. This status-based approach to justice created a system where the wealthy and powerful could commit sexual violence with relative impunity. Records from the medieval Court of Common Pleas in England reveal cases where accusations against lords or knights were dismissed with minimal investigation, while similar charges against commoners proceeded to harsh punishment. Medieval Venetian court documents tell of cases where servants raped by their masters had their testimony dismissed entirely, based solely on the social disparity between accuser and accused. The prevailing assumption was that lower-class women might fabricate accusations for financial gain, despite little evidence supporting this prejudice. Even more telling was how medieval law treated prostitutes who were sexually assaulted. In many jurisdictions, raping a known prostitute was either not considered a crime at all, or was punished far less severely. Legal codes from medieval cities like Nuremberg and Florence explicitly stated that prostitutes had fewer legal protections regarding sexual assault. The underlying logic was that women who had commercialized sex had somehow surrendered their right to refuse sexual contact, a logic that completely disregarded the concept of ongoing consent. This status-based approach to sexual crimes wasn't just an informal practice, but was codified in many medieval legal systems. The 13th century Castilian law code, known as La Siete Partidas, explicitly prescribed different punishments based on the social status of both parties involved, establishing a sliding scale of justice that privileged the elite and further marginalized the Number 7. Public reputation could make or break a case. In medieval courts, a woman's public reputation often determined whether her accusations of sexual assault would be believed. This focus on reputation created a system where community gossip and perception could completely overturn the course of justice, regardless of the actual facts of a case. Medieval court records from across Europe reveal that women with questionable reputations faced nearly insurmountable barriers when accusing men of rape. A woman known to have had previous sexual relationships, especially outside of marriage, would find her accusations scrutinized far more severely than those made by a woman considered virtuous. Court proceedings from 14th century Bologna show judges explicitly questioning witnesses about the victim's character before even addressing the details of the alleged assault. The concept of fama, public reputation, or rumor, held tremendous legal weight in medieval judicial systems. If a woman was rumored to be sexually active or flirtatious, these rumors could be introduced as evidence against her in court. Conversely, a man with a good reputation in the community might escape punishment despite compelling evidence against him. Church courts were particularly fixated on reputation when handling sexual crime cases. Canon law procedures often required character witnesses to testify about the victim's previous behavior, creating a system where community perception of a woman's sexuality directly impacted her access to justice. Records from ecclesiastical courts in 15th century England show cases dismissed solely because witnesses testified that the accuser had a loose reputation. This focus on reputation created a perverse incentive structure. Women knew their past would be scrutinized in court, leading many to avoid reporting sexual assaults altogether. Historical records suggest many victims chose silence over the public humiliation, of having their sexual history examined in open court. The reputation factor affected men too, though differently. Men with high standing in the community could more easily defend themselves against accusations by gathering character witnesses to testify to their good nature. Medieval court records from places like Toulouse and Frankfurt show cases where prominent men accused of rape were acquitted primarily because local guild members or church officials vouched for their character. This system effectively created two tiers of justice, based on community perception rather than evidence. A woman considered virtuous by her community had a chance at seeing her attacker punished, while women with damaged reputations, often through no fault of their own, found themselves unable to secure legal protection or justice when victimized. Number 6. Proving rape required nearly impossible standards. Medieval legal systems made proving sexual assault extraordinarily difficult through evidentiary requirements that were nearly impossible to meet. These standards, many of which would be considered absurd by modern legal principles, effectively prevented most victims from securing convictions against their attackers. One of the most common requirements in medieval courts was the hue and cry. Victims were expected to immediately call out and alert neighbors during or immediately after an assault. Court records from 14th century England show cases dismissed because the woman hadn't raised sufficient alarm even when the assault occurred in isolated locations where no one could have heard her calls. This standard completely disregarded the effects of trauma, which often include shock and inability to immediately respond. Physical evidence requirements were equally problematic. Many medieval legal codes required visible injuries as proof that a woman had fought back sufficiently. The 13th century legal text Fleda specifically required torn clothing, blood, and bruising as evidence of resistance. This standard ignored cases involving threats, coercion, or situations where victims froze from fear, all common responses to sexual assault that modern psychology recognizes but medieval courts did not. Perhaps most notoriously, many jurisdictions required eyewitnesses to the crime. Since sexual assault typically occurs in private, this requirement essentially made conviction impossible in most cases. Records from the medieval courts of Aragon show numerous cases dismissed solely due to lack of witnesses, even when other evidence strongly suggested guilt. Pregnancy, resulting from rape, created another evidentiary paradox. Some medieval legal theorists, following misguided biological theories dating back to Aristotle and Galen, believed that conception could only occur if a woman experienced pleasure during intercourse. This led to the twisted logic that pregnancy following alleged rape was evidence that the woman had actually consented. Court records from 15th century Germany show cases where pregnancy was used to dismiss rape charges rather than being seen as evidence of the crime. The timing of accusations was also scrutinized. Women were expected to report assaults immediately. Any delay was interpreted as evidence of fabrication. Medieval French court records contain cases dismissed because the victim waited even a day before reporting, regardless of valid reasons like injury, trauma, or fear of retaliation. These evidentiary hurdles combined to create a system where most victims could not possibly meet the required legal standards. Historical research suggests that conviction rates for reported sexual assaults in medieval courts were extraordinarily low, often less than 5% in jurisdictions where records have survived in sufficient detail to make such calculations. Number 5. The Church added both protections and complications. The Catholic Church's involvement in medieval rape law created a complex and sometimes contradictory layer of justice that could both help and harm victims. As the dominant religious institution with its own extensive legal system, the Church's approach to sexual crimes significantly shaped how medieval society understood and addressed these offenses. On one hand, ecclesiastical courts sometimes offered women options that secular courts did not. Church authorities occasionally took a more victim-centered approach, particularly in cases involving forced marriages or sexual assault by clergy members. The archives of medieval diocesan courts from places like York and Paris contain cases where church officials provided refuge to women fleeing sexual violence when secular authorities refused to intervene. The Church's emphasis on consent in marriage occasionally extended to broader questions of sexual consent. Several influential medieval theologians, including Thomas Aquinas, argued that sexual relations required mutual agreement, which represented a more progressive view than many secular authorities held. This theological position sometimes translated into more sympathetic treatment of victims in church courts. However, the Church's involvement also created significant problems. Ecclesiastical authorities were primarily concerned with sin rather than crime, often focusing more on moral transgression than on harm to victims. This meant that church courts sometimes premonitized having perpetrators perform penance over providing justice or safety to those who had been assaulted. The Catholic Church's obsession with female virginity and chastity created additional burdens for victims. Rape victims were sometimes viewed as having lost their spiritual purity, regardless of their lack of consent. Historical records from convent investigations show cases where sexually assaulted nuns were punished alongside their attackers for violations of chastity, revealing how blame was often distributed to victims as well as perpetrators. Church courts also promoted the troubling concept of spiritual reconciliation between rapists and victims. Documents from medieval church tribunals show cases where victims were pressured to forgive their attackers as part of the resolution process, premonitizing religious notions of forgiveness over justice or victim safety. The overlapping jurisdiction between church and secular courts created additional complications. In many regions, cases could move between ecclesiastical and secular authorities, sometimes resulting in contradictory rulings or allowing perpetrators to escape justice by appealing to whichever system seemed most likely to rule in their favor. Records from 14th century Florence show cases bouncing between civil and church authorities for years, extending victims' trauma through prolonged proceedings. Church influence on secular law also shaped rape legislation in problematic ways. Many medieval legal codes incorporated religious concepts about sexuality that complicated rape cases, such as the notion that all non-marital sex was sinful, a perspective that sometimes blurred the crucial distinction between consensual sex outside marriage and sexual assault. Number 4. Abduction and rape were often legally equivalent. One of the most distinctive features of medieval rape law was the frequent conflation of rape with abduction or kidnapping. In many medieval legal codes, these were treated as essentially the same crime, revealing much about how society conceptualized sexual violence. The Latin term raptus, which forms the etymological root of the modern word rape, originally referred primarily to abduction rather than sexual assault. Medieval legal documents from across Europe used this term to describe both kidnapping a woman and sexually assaulting her, often without distinguishing between these very different offenses. This linguistic ambiguity reflects a legal system that saw both crimes primarily as violations of male authority over women rather than as attacks on women themselves. Court records from medieval England show this conflation in practice. Under English common law, the crime of rape could be charged whether or not sexual assault had occurred. The unauthorized taking of a woman from her father's or husband's control was the essential element of the crime. The 13th century legal treatise, known as Bracton, explicitly described rape as the violent abduction of a woman from her home, focusing on the kidnapping aspect before addressing sexual violation. This conflation had significant consequences for how cases were prosecuted. If a woman was taken from her home and then sexually assaulted, medieval courts often focused primarily on the abduction element rather than the sexual violence. Records from the medieval English Court of King's Bench show numerous cases where the kidnapping aspect dominated legal proceedings, with the sexual assault mentioned only secondarily, if at all. Even more troublingly, this legal framework created situations where consensual elopements could be charged as rape. Historical records reveal cases where couples who ran away together faced rape charges brought by the woman's family, even when she testified that she had consented to both the elopement and the sexual relationship. From the medieval legal perspective, the woman's consent was less relevant than her guardian's permission. This abduction focus particularly affected how interclass and interreligious relationships were handled. Cases from medieval Spain show Muslims charged with rapto, rape abduction, for relationships with Christian women, even when these relationships were consensual, and similar cases appear in records from regions with Jewish-Christian tensions. The rape abduction charge became a tool for enforcing social and religious boundaries. The punishments reflected this abduction-centered understanding. In many medieval jurisdictions, returning the woman unharmed to her family could result in reduced punishment, even if sexual assault had occurred. This approach prioritized restoring the disrupted family structure over addressing the sexual violence the woman had experienced. This conflation gradually began to change during the later medieval period. By the 15th century, some jurisdictions were beginning to distinguish more clearly between cases of abduction and cases of sexual assault, though complete legal separation of these concepts wouldn't occur until much later. This slow evolution reflects the gradually shifting understanding of rape from a property crime to a crime of violence. Number 3. Children had few legal protections. Medieval legal systems offered shockingly little protection to child victims of sexual abuse, with age of consent concepts being rudimentary at best and often completely absent. The vulnerability of children in medieval society was reflected in legal codes that failed to recognize their special need for protection against sexual predation. While modern legal systems establish clear age of consent laws, medieval jurisdictions typically relied on much vaguer standards related to physical development rather than chronological age. Canon law, church law, established that girls could legally consent to marriage once they reached puberty, often interpreted as age 12. While boys were considered capable of consent at 14. However, these same standards were frequently applied to questions of sexual consent outside of marriage, creating a situation where extremely young individuals were legally considered capable of consenting to sexual activity. Court records from medieval England reveal cases involving victims as young as 10 or 11 where courts still investigated whether the child had consented, showing a fundamental misunderstanding of children's capacity to consent to sexual acts with adults. The legal concept of statutory rape. The understanding that children below a certain age cannot meaningfully consent regardless of circumstances simply did not exist in medieval jurisprudence. Even more troublingly, medieval courts often applied the same stringent proof requirements to child victims as they did to adults. Historical records from 14th century French courts show cases where children were expected to have raised the hue and cry immediately, shown physical evidence of resistance, and secured eyewitnesses, standards that were inappropriate and impossible for young victims to meet. The legal language around child sexual abuse was often euphemistic and minimizing. Court documents frequently described such attacks as defilement rather than assault, focusing on the child's loss of purity rather than the predatory nature of the perpetrator's actions. This framing continued to place responsibility on victims rather than perpetrators. Class distinctions severely impacted what little protection existed for children. Records from various European courts show that sexual crimes against children of the nobility were taken more seriously than identical crimes against peasant children. A 15th century case from Milan shows a merchant executed for assaulting a nobleman's daughter, while in the same year, a similar case involving a peasant child resulted only in a fine. Particularly vulnerable were orphan children and those in domestic service, who faced frequent sexual exploitation with minimal legal recourse. Medieval household structures placed young servants in close proximity to their employers with little oversight. Court records and church penance records contain numerous references to masters sexually abusing young servants, yet these cases rarely resulted in significant punishment. The most consistent protection for children came from the Church's prohibition on sexual contact with prepubescent children, classified as a serious sin. However, this religious prohibition often resulted in penance rather than legal punishment for offenders. Ecclesiastical court records show that perpetrators were frequently assigned prayers, fasting, or temporary exclusion from sacraments rather than suffering legal consequences for abusing children. Number 2. Punishment severity varied dramatically by region. The punishment for rape in medieval Europe was far from standardized, with enormous variation depending on geography, local customs, and the specific legal tradition in place. This created a patchwork of justice where the consequences for the same crime could range from a small fine to execution depending entirely on where it occurred. In some regions, particularly those following Germanic legal traditions, rape could be punished with remarkable severity. The Visigothic Code, influential in parts of medieval Spain, prescribed death for rapists as well as the confiscation of their property, which would then be given to the victim. Similarly, some medieval Scandinavian legal codes mandated outlawry, essentially civil death, where the convicted person could be killed without legal consequence for convicted rapists. By stark contrast, other regions treated sexual assault as a relatively minor offense. Records from some Italian city-states in the 13th and 14th centuries show cases where convicted rapists received only modest fines, essentially treating sexual assault as a minor infraction rather than a serious crime. Court documents from medieval Perugia reveal a case where a nobleman convicted of raping a peasant woman was fined roughly the equivalent of a week's wages. Hardly a deterrent punishment. Islamic law, which governed parts of medieval Spain and influenced legal systems around the Mediterranean, took yet another approach. Under various interpretations of Sharia law practiced in Al-Andalus, Islamic Spain, rape was considered a serious crime, requiring multiple witnesses, but when proven could result in severe corporal punishment or execution, particularly if the victim was married. Byzantine-influenced regions of Eastern Europe followed traditions derived from Roman law, as modified by Christian rulers. The Byzantine legal code, known as the Ecloga, prescribed nose-cutting as punishment for sexual crimes including rape, a penalty that emphasized public shame and visible marking of offenders. Court records confirm this gruesome penalty was actually implemented in some cases. England's approach evolved significantly during the medieval period. Early Anglo-Saxon laws treated rape primarily as a property crime, requiring compensation to the victim's male relatives. But by the 13th century, rape had been reclassified as a felony, potentially punishable by death. However, historical records show this harsh punishment was applied inconsistently, with many convicted rapists receiving lesser penalties or pardons, particularly if they had political connections. France developed a similarly inconsistent system. The 13th century legal text, Les Ablissements de Saint Louis, prescribed hanging for rape, but court records from various French regions show wildly different implementation, with some jurisdictions rudely commuting this to lesser punishments, while others enforced it strictly. Adding to this regional complexity were the special jurisdictions that existed throughout medieval Europe. Ecclesiastical courts, university courts, guild courts, and manorial courts each had their own procedures and punishment scales for sexual crimes. A university student who committed rape might be judged by university authorities with different standards than a townsman who committed the same offense just outside university grounds. This geographical lottery meant that victims' access to justice depended heavily on where the crime occurred and which legal tradition prevailed there. The lack of standardization reflected medieval Europe's fragmented political landscape and the absence of unified criminal codes that would come only in later centuries. Number 1. False accusations were harshly punished. Medieval legal systems approached accusations of rape with extreme suspicion and imposed severe penalties on those deemed to have made false allegations. This approach created a chilling effect that likely deterred many legitimate victims from coming forward, fearing they might face punishment if they couldn't prove their cases. Court records from across medieval Europe reveal a consistent pattern of harsh repercussions for women whose rape allegations weren't believed. In many jurisdictions, if a woman's accusation failed to result in conviction, she could find herself facing prosecution. The legal principle of talion that false accusers should suffer the punishment their accused would have faced was applied with particular vigor in sexual assault cases. This meant that a woman whose rape accusation wasn't proven could potentially face execution in regions where rape carried the death penalty. Historical documents from 14th century France show cases where women who couldn't prove their rape allegations were themselves fined, imprisoned, or publicly humiliated. In one documented case from medieval Toulouse, a woman whose rape accusation was rejected by the court was sentenced to have her lips cut, a particularly symbolic punishment designed to discourage other women from making accusations. This approach fundamentally misunderstood the nature of sexual crimes. Given the nearly impossible evidentiary standards required to prove rape in medieval courts, many legitimate victims inevitably failed to secure convictions. The system then compounded their trauma by treating them as liars, deserving punishment, rather than as victims who simply couldn't meet unrealistic proof requirements. The fear of punishment for false accusations created a perverse incentive structure. Records from ecclesiastical courts across Europe contain cases where women withdrew rape allegations after realizing they couldn't produce the required eyewitnesses or evidence explicitly stating they feared counter-prosecution. This dynamic allowed many perpetrators to escape justice entirely. Medieval legal commentators explicitly encouraged this suspicious approach to rape allegations. Influential legal texts, like Italy's Lombard laws, contained warnings about women fabricating rape charges, reinforcing the idea that allegations should be treated with extreme skepticism. This presumption against believability directly contradicts modern understandings about the rarity of false rape reports. The system was particularly suspicious of certain categories of accusers. Court records indicate that lower-class women accusing higher-status men, women with any history of sexual activity, or women who had delayed reporting were especially likely to face counter-accusations of falsehood. This created additional barriers for the most vulnerable victims in medieval society. This approach to alleged false accusations wasn't applied equally across genders. When men accused other men of crimes and failed to prove their cases, they rarely faced the same severe consequences that women did for unproven rape allegations. This gender disparity reveals how concerns about false accusations were disproportionately applied to female victims of sexual crimes. What would medieval people think of modern sexual assault laws? How can understanding historical approaches to rape help us recognize continuing problematic attitudes today?